Hello guys, welcome all of you. Welcome to this discussion of the law optional question paper number 1 with GS score. In this discussion, we are going to discuss about the level of the question paper this year, and second, the main point, whether like what should be the model answers of all such questions, along with the main discussion which I just want to have with all of you. I always recommend that law optional has become the choice of the UPSC aspirants since last 7 or 8 years, because students have witnessed that law optional has the highest success ratio, number one, and second is it is one of the easiest subject, because you already cover so many things in the general studies paper as well. So that is the reason this law optional paper is always beneficial, mainly for the law students as well as for the non-law students as well. Okay, so in this discussion, I will be first letting you know the level of the question paper. If I go with the law students, the level of this question paper is very, very, very easy, because they are clear about their fundamentals, and in this question paper, the only thing which a student requires, just relate the conceptual clarity with the current cases, the latest cases, or the landmark cases, or the recent situations only. You do not require anything else. Simple. And even if you are a non-law graduate, this paper is very easy for all of you. Because when we talk about paper 1, the constitutional law and the administrative law, you already cover all these things in Indian polity and governance. And when we talk about the international law, the part 2 of this paper 1, it is, you can say, you have to just prepare few points only, and rest you can relate those things with the topics covered in international relations. So automatically this paper, you can say the subject law optional, is obviously beneficial for all of you. So if you get an understanding how to write down the answers that I will discuss with you when I will be discussing about the model answers of this question paper, you will be definitely getting an idea that law optional is going to be your perfect choice. Okay, so in this discussion, as I mentioned you, the level of question paper is very easy. Many of the questions are straightforward, but the only thing which you require, the relationship of that particular legal provision with the current case or the current situation. Like for example, all of you must have gone through that in Maharashtra, the OBC reservation in local elections. Same thing happened in Madhya Pradesh as well. So this question has come in this paper this time. So many of the questions which you can see, if you observe this question paper, you can get an idea that if your current affairs are really very well, you could have attempted this question paper even without studying the law. Okay, so starting with this question and paper 1, we have number 1 with us, question number 1, part A. Absolute equality may itself be a cause of inequality. In the light of this statement, discuss substantive equality. So if you are clear about what is substantive equality and what is absolute equality and what is inequality, if you can relate absolute equality with inequality and then you can conclude that why do we require substantive equality, your answer is complete. So I will be first telling you what you should write, what are the legal provisions or constitutional provisions involved in this question, and then I will discuss with you. And automatically you will be getting an understanding that, in answers, UPSC is not expecting you be to an expert of each and everything. They just want to check out your conceptual clarity. So if you go by this particular question, so first of all, we have to focus upon right to equality. And when we talk about the right to equality, which are basically given in Article 14 till Article 18 actually. From Article 14 till Article 18, we have been given about the kind of equalities. And along with this, we have to discuss about the directive principles of state policy, and more specifically, Article 31C. Article 31C. And Article 39, Clause B, along with Clause C. So if you can relate Article 14 till 18 along with DPSP, Article 31C and Article 39, Clause B and Clause C, this is one of the points which you should mention in your answer. And second, the relevant case laws. The relevant one of the case law which starts is given in Sanjeev Coke Manufacturing Company versus Bharat Cooking Coal Limited of 1983. One of this case you can mention. And then when you have to relate this inequality and substantive equality, you can also mention about reasonable classification. I'm just mentioning, I'm giving you a hint that how you should basically be clear about the contents of your answer. Because if you are clear that what should be the contents of the answer, this will be helping you out to write down a perfect answer. Okay. So reasonable classification. And another case which you can refer to justify that how absolute equality can cause inequality. One of the interesting case is State of Bihar versus Bihar 10+2 Lecturers Association. And also you can mention about at the concluding point the concept of reservation, how reservation is creating substantive equality, or even during the COVID-19, the way government of India has given, the vaccination program, how the government has implemented the vaccination program, that is also one of the factor you can mention over here. So the starting point of discussion is basically, what is the meaning of absolute equality? First, we should understand the meaning of absolute equality. The meaning of absolute equality in a very simplest meaning is that when all peoples are treated equally, regardless of their race, sex, caste, religion, or gender. So, absolute equality means when all peoples are treated equally, irrespective of any other differentiating parameter. But when we talk about the substantive equality, it is the, you can say, modified or the advanced version of this equality, which says the underlying idea is you cannot treat equals with unequals. So you should treat equals with equals, unequals with unequals. Okay, or you should provide opportunity to the unequals so that they are capable to be compared with the equals. So when we talk about the substantive equality, this concept recognizes that law must take some elements into consideration, such as discrimination, marginalization, unequal distribution, into account in order to achieve equal results for basic human rights. Basically, we know very well that India is a welfare state. And all of you are very well aware that we have the concept of right to equality and Article 14, 15, 16, 17, 18, which talks about the equality that every person should be treated equally. And along with this discussion, we know very well that these sections are not giving you any absolute right. Every right is subject to certain reasonable restrictions. So in Article 14, we have been given the reasonable classification concept, which is against the, which is in, you can say, contrary to the class legislation. And even our Constitution of India permits reasonable classification based upon intelligible differentia. So once you are getting, the kind of the words, if you get in your mind like, oh, I have to mention these points. and these points, and if you relate this with the current situation, your answer is complete now. You are not supposed to be worried every time. You should not be basically, thinking unnecessarily. Just get an idea what can be the contents of my answer. That will make your answer suffice. So in this case, if you see, first start writing about the right of equality given in the constitution, then mention about that why, first explain absolute equality, explain substantive equality, explain why absolute equality can be a cause of inequality, because when you treat equals with unequals, this will obviously cause inequality. So either you make unequals equal or you treat them with the unequals only. Why I mentioned that the state of Bihar versus Bihar 10+2 lecturers association case to you. In this case, this is very interesting case actually. In this case, what happened, there was, you can say, a few lecturers who were trained actually, and there are few lecturers who were untrained. So government has designed separate rules and separate kind of, you can say, pay scale for the trained lecturers, and for untrained it was something else. So it is a reasonable kind of classification, you should say, because if you treat the trained lecturers with the untrained lecturers, this will cause a grave error in justice. Okay, so the point and the underlying idea of this question is why we should be basically treating the marginalized section of the society or the underprivileged section of the society in a different manner. So reservation is also one of the idea. Why reservation is being given? Because we know very well that there is a particular section of society which is socially and economically backward. So once you are socially or educationally or economically backward, then obviously that particular backwardness should be meted with, you can say, a separate class of persons. But that should be based upon the reasonable classification. That should not be based upon class legislation. And you know very well that reasonable classification is based upon the kind of objective they want to achieve in a social welfare state in an intelligible differentia. So if you mention these points, your answer is complete. Then you can mention few cases, like for example, we have been given a case called Sanjeev Coke Manufacturing Company versus Bharat Coking Coal Limited Company, 1983 case, in which Supreme Court has categorically mentioned, that the directive principles of state policy, and the Article 31C, which provides primacy to Article 39 Clause B and Clause C. So this particular provision makes Article 39B and Article 39C superior than Article 14. So if it is in the interest of the society, if it is interest of the justice, that we should provide certain benefits to the underprivileged, marginalized section of society, that should be allowed. So that is the reason Article 39 Clause B and C are superior than, in hierarchy, they are superior than Article 14. So you just mentioned this point. So you are justifying why substantive equality is more crucial to the society. So if you can relate right to equality with DPSP along with these cases and the reasonable classification, this makes your answer complete. And then in concluding points, you can mention about the reservation, how reservation is beneficial for the society if it is being applied in a proper manner. If we get some time to have a discussion in a classroom program, then I will discuss with you about the proper implementation of the reservation program. Okay, because the kind of reservation policy we have in our country, it is somehow politically motivated. We should have a refined version of this reservation system in our country. Okay, anyhow, then you can also mention about COVID-19, how this COVID-19 policy, when it was implemented by the government, the vaccination program. So in this COVID-19 vaccination program, first of all, government gave an opportunity to the doctors, health workers, and then to the senior citizens, because they were at, you can say, higher risk of this impact of this COVID-19. And later on, this COVID-19 vaccine program was implemented for the other sections of the society. Okay, to the other persons as well. So in a step-by-step manner, this COVID-19 vaccination program took place. But suppose if COVID-19 vaccination program could have been opened for everyone, then this could have created an inequality, because the health workers, the doctors, or the persons like the persons who are standing at front and who were fighting with this COVID-19, okay, and the senior citizens. So this would have caused greater inequality to the society. So this COVID-19 vaccination program, this reservation system, you can just quote 2 examples only. It is more than sufficient, because this is only 10 marker question. Okay. So by referring this discussion, you just get an idea how exactly you should relate the topics, okay, with the current affairs. So by this way, you are just completing your answer. No need of mentioning anything else now. Simple. Okay. Now coming to question number 2. To preserve the basic, question number 1, part B, to preserve the basic freedoms and dignity of individuals, a constitution should be permeated with the constitutionalism. So basically, UPSC generally ask or use such kind of words which you might not have heard in your life. Okay, like for example, be permeated, like to preserve the basic freedom and dignity of the individuals. So this kind of question UPSC has asked in the past as well many a times, but the wording is a little bit different actually. So the ultimate point of this question is basically you have to just prove that how this constitutionalism is important for the society at large. How it is important to preserve the basic freedoms. Basic freedom means when we talk about the fundamental rights actually, and dignity. Once again, it is in within the ambit of the fundamental rights only. So you have to just mention how the constitutionalism is important for the proper, you can say, enforcement of the fundamental rights, and up to some extent about the DPSP as well. So in this scenario, you start writing with the salient features of constitutionalism. Salient features. Like for example, you can mention about the distribution of powers. First, start explaining the constitutionalism, because we know very well constitutionalism is a mechanism to keep a check and balance upon the arbitrary powers of the government. So it is basically about controlling or regulating the sovereign, the government, the power, the authority. This particular constitutionalism concept provides that the government should not be using its power in an arbitrary manner. For that purpose, our constitution already has few features which provides a mechanism of keeping a check upon the powers of the government. Like for example, number 1, distribution of powers. In India, our constitution has clearly given that the powers are already bifurcated between the union government and the state governments. Okay, and there are some concurrent kind of matters as well under the domain of both kind of governments. Then the independent judiciary. Independent judiciary, and more specifically, you should mention also about judicial review. That all kind of laws made by the parliament, they are subject to the judicial review as well. Then you can also mention about the supremacy of the constitution. Supremacy of the constitution. So first of all, try to mention about how this constitutionalism is given, in our constitution itself. And then try to relate why constitutionalism is necessary. Because constitutionalism is necessary so that the society should not turn against the society itself. The government should not turn against the society. The government should not become absolute. Government should not wield absolute power against the society. Otherwise, your law will be, it will be losing your ultimate objective. So once you mention few features of the constitution which are, which are with respect to the constitutionalism, and then try to mention about why a person requires basic freedoms and dignity, why it is necessary. So basically, fundamental rights and directive principles of state policy, they basically keep a check upon the society. Even DPSP, sometimes people say DPSPs are in conflict with the fundamental rights. No, it is not correct approach. Sometimes it is basically seen that yes, they are in conflict, but ultimately fundamental rights and DPSP both are supplementary and complementary to each other. Actually, because in DPSP, it casts a liability upon the government that they should act as a welfare state. So if you are about to work as a welfare state, it is necessary for you that you should pay heed or consideration to the fundamental rights mainly. Because it is the ultimate objective of any welfare state that they should work for the maximum benefit of the society only. So if you can mention only these points and try to just conclude that the fundamental rights are necessary because every human being is made by the nature equally. Now the natural law school, you can relate over here. Natural law school as well. Generally, people are not aware about this natural law school because they have just considered the natural law school or judiciary subject, this jurisprudence subject, unnecessary. They just thought that it is a, useless subject. But this is not the useless subject. It is one of the interesting subject and one of the most important subject for any law candidate. So you just mention why basic freedoms, basic rights are necessary for any human being. Just write that right to life, right to liberty, freedom of speech and expression, right to equality. These are the fundamental rights which are necessary for the proper survival of the human being, for the proper existence of the human being. Because it is the nature who has created us. And when nature has created the human beings, we all are equal. And once we are all are equal, ultimately I just want to mention you, the ultimate origination of the fundamental rights actually, it emanates from the natural law school only. So in this way, you can just conclude this question as well. No need of mentioning anything else. If you remember any judgment about the relationship of these things, you can mention, like Minerva Mill case, you can also mention. Okay, otherwise no requirement of mentioning anything else. So your answer will be complete because it is a 10 marker question. You have to write only in 150 words. So by this way, you can be completing 150 words only. Because at the max, you have to just write down maximum 10 to 12 lines. So in this way, you will be completing this answer. Okay. Now moving forward, question number 1, part C. Explain the legal position in case of the repugnancy between the union and the state laws with the help of the decided case laws. Which law shall prevail in case of repugnancy? So basically, first of all, we should understand what is repugnancy, and for that purpose, we can refer Article 254. I'm just mentioning you the contents which all of you should be aware. What should you write over here? And then the cases you can mention. One of the main case in which this doctrine was actually applied by the Supreme Court is M. Karunanidhi versus Union of India, 1979. And the second case which you can mention, Zaveri Bhai versus State of Bombay. So in this case, by mentioning M. Karunanidhi case, because M. Karunanidhi case is one of the landmark case in this direction. So first of all, what is this doctrine of repugnancy? First, try to explain this. Because explain the legal position in case of repugnancy between the union and the state laws with the help of the decided case laws. And which law shall prevail? For that purpose, Article 254, which provides, I am just reading Article 254 for the convenience of all of you. If any provision of law made by the legislature of the state is repugnant to any provision of a law made by the parliament, which is competent to enact or to any provision of the existing law with respect to with respect to one of the matters enumerated in the concurrent list, then the law made by the Parliament, whether passed before or after the law made by the legislature of such stage, or as the case may be, the existing law shall prevail and the law made by the legislature of the state shall, to the extent of the repugnancy, be void. So if you understand the crux of this Article 254, it simply says it applies where there is any inconsistency between the central law and the state law relating to a subject mentioned in the concurrent list. So if there is anything given in the concurrent list, because you know very well, on concurrent list, both state government as well as union government has the power. But if union government has made any law which is in repugnancy with the state law, then it is the parliament law which will be applicable, and the state law will become void up to that extent. In M. Karunanidhi case, Justice Fazal Ali, he reviewed all earlier judgments and he summarized the test of repugnancy. So if you guys are aware about this M. Karunanidhi case, then it is okay. You must be knowing that. Otherwise, I request all of you, please read this case only. Because this case itself is, you can say, final decision, which actually summarizes how this doctrine of repugnancy is being applied. So I'm just reading only few points of this particular judgment. Before applying this doctrine of repugnancy, you can say, first of all, repugnancy would arise between the two statutes in a specific situation, and the situation is, it must be shown that there is a clear and direct inconsistency between the two enactments, central and the state law, which is irreconcilable, so that they cannot stand together or operate in the same field. So this irreconcilable provision between the state and the central law is one of the issue. Further, there can be no repeal by implication unless the inconsistency appears on the face of the two statutes. And where the two statutes occupy a particular field, but there is a room or possibility of both the statutes operating in the same field without coming into collusion with each other, no repugnancy results. So these are the few guidelines laid down by the Justice Fazal Ali in case of this repugnancy, the test of repugnancy actually. And one of the interesting point which all of you should focus upon, Article 254 Clause 2 as well. Because it says, the above rule of repugnancy, it is an exception actually to this rule. It says, according to Clause 2, if a state law with respect to any of the matters enumerated in the concurrent list contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then the state law, if it has been reserved for the assent of the President and has received his assent, so it means if the President has given the assent to the state law, it shall prevail, notwithstanding such repugnancy. Okay, but it would still be possible for the Parliament under the provision of Clause 2 to override such law by subsequently making a law on the same matter. So this M. Karunanidhi judgment as well as Article 254 simply provides, if in the concurrent list matters, if any conflict is there between the central law and the state law, it is generally the central law which shall prevail. But Article 254 Clause 2 provides, if the state law has been approved by the President, then state law shall prevail. But that state law approved by the President can be, you can say, subsequently changed by the Parliament as well. So by this way, we try to maintain a balance in such case of our country, which is having quasi-federal nature actually. Okay. And then finally, you should conclude by mentioning this M. Karunanidhi judgment. First, you mention M. Karunanidhi judgment. No need of mentioning the facts of this case. If you remember, it's okay. If you do not, then it is also okay. So don't worry. You have to just mention the crux. The question of repugnancy between parliamentary legislation and the state legislature arises in two ways. First, where the legislations are enacted with respect to matters allotted in their fields, but they overlap and conflict. Second, where the two legislations are with respect to matters in the concurrent list and there is a conflict. In both the situation, the parliamentary legislation will predominate. In first case, by the virtue of Article 246, Clause 1. In the second scenario, by the virtue of Article 254, Clause 1. So, Article 246, Clause 1 as well you can mention. For your convenience. Okay. Then you can also mention this Javeri Bhai case as well, whereby the Parliament had enacted the Essential Commodities Act, Essential Supplies Act actually, in 1946 for the regulation of supply and distribution of essential commodities. So basically, in this particular case, the contravention read that if any person is violating such law, he will be punishable with 3 years of imprisonment or fine or both. In 1947, in Bombay, the Bombay government had a view that this punishment is inadequate. So accordingly, they passed an act and they enhanced the punishment. So, and the Bombay Act received the approval or the assent of the president as well. So you can say, if president has given his assent in this concurrent list matter, so accordingly that law should also be applicable over the parliament law. But in 1950, Parliament amended this original act once again and they also enhanced the punishment. So in such a case, you can say both occupied the same field, that is enhanced punishment, and the state law became void after, you can say, the amendment of the law by the central government. So in such a case, you can just conclude that in case of repugnancy, what happens? But first, explain what is repugnancy, how it arises, in which case the guidelines were laid down, and accordingly conclude in your own words. Simple. Which law shall prevail? So I have given this answer as well through this judgment. So this is more than sufficient for you to write down in 10 marker question. No need of mentioning unnecessary things. Okay. Then we have another question, question number 1 part D. What are the tests laid down by the Supreme Court in the recent decision quantifying and providing quota for the other backward classes in the local body elections? So guys, all of you should be knowing very well that it is a recent case actually, and in this recent case, all of you should be very well aware that this situation actually arose in Maharashtra. But before that, all of you should be knowing, they are asking about the Supreme Court judgment. So over here, I am just mentioning the contents which all of you should mention. Number 1, you should mention K. Krishnamurthy versus Union of India judgment 2010, and more specifically the articles which were involved, Article 243D Clause 6 and Article 243T Clause 6, which actually provides for the reservation in the panchayat and the municipal elections actually to the, you can say, backward classes. So the reservation to the backward classes in the local body elections, you can say. And in this case, Supreme Court laid down 3 test criteria. 3 test criteria, or you can say 3 conditions actually, that before giving the quota to the other backward classes in the local body elections, government has to fulfill these 3 requirements first. Then only this reservation will be applicable, otherwise it will be void. And that was the outcome, because ultimately what happened, Supreme Court in this 3 test criteria has mentioned about the empirical data. Empirical data. So if you are having empirical data with you, and if you are giving the reservation on that basis, then it is justified, otherwise it will be void. And another case which you can mention, Rahul Ramesh Singh versus State of Maharashtra, the recent case actually, in which this controversy actually arose. Okay, and the limit of this quota as well is 50%. So I will just tell you the recent the guidelines given in this judgment by the Supreme Court, and then you can decide what should be the answer in such a case. Okay, so I just mention you first the question, actually the point about this OBC quota. So the triple test criteria. So this triple test criteria is actually, you can say, because in Maharashtra and even in Madhya Pradesh as well, the government has applied this reservation without collecting the quantifiable data. Because one of the conditions given by the Supreme Court was that this total reservation, so first of all, it should not exceed the limit of 50%. Okay. So the triple test criteria basically required the state should appoint number one, the commission. State should collect quantifiable data of the community and then allocate the reservation to them in the local bodies in such a manner that the total reservation should not exceed 50% limit. So basically, Supreme Court has given this ruling and this triple test criteria was laid down. Okay, in this K. Krishnamurthy case. Later on, Supreme Court had directed the states to notify, even in case of Madhya Pradesh as well. And the same thing is applicable in Maharashtra, and even Supreme Court said that this particular triple test criteria is applicable across the country. It is not like that in every time every state should get this, this final judgment from the court itself. This particular triple test criteria is applicable to all, all states across this country. So you can say, the main idea of this particular question, the government, the UPSC is mainly focused upon when Supreme Court permitted Madhya Pradesh to provide reservation to the OBC in local body election and modifying the earlier order that suspended the quota due to the lack of data. So the ultimate point is actually, like for example in Madhya Pradesh has quota actually already for the scheduled caste, scheduled tribes and women. So Madhya Pradesh government wanted to apply the reservation to the other backward classes as well. For that purpose, Madhya Pradesh government had applied and given the reservation, but Supreme Court earlier had struck down or suspended this application of the reservation in the local elections of the OBC. Because Supreme Court has clearly said that reservation is obviously permissible because, obviously due to the lack of representation that might be a scenario, but before applying this reservation, the state government has to completely fulfill this criteria, otherwise this reservation will become void. Okay, even earlier the Supreme Court, by hearing a plea by the Maharashtra government, they specifically mentioned that without appointment or without the empirical data, without the quantifiable data, you cannot give reservation to the OBC in the local elections. So finally, what is the outcome? What you should mention in this case basically? You have to first mention about the origination of this triple test criteria in K. Krishnamurthy case. Then mention about the parameters laid down by the Supreme Court. Then you can also mention about how this Article 15.4 and Article 16.4, which are basically about the basis for the reservation in education and employment, how it is different from these articles. Because Article 15 clause 4, Article 16 clause 4, they talk about the reservation in education and employment. But this kind of reservation, the provision, we have to refer Article 243D and 243T. So Supreme Court has said that the whatever kind of data you have with respect to education and employment is not applicable over here. For application of reservation in this case as well, you require quantifiable data, then only you can give the reservation, otherwise not. Okay, so by this way you can just conclude this particular case, this particular question. 10 marker question, 150 words. Please keep this in mind, the time limit and the words limit. Okay. Then coming to next question, number 1 party, elucidate the Wednesbury principle of unreasonableness Do these principles provide in any way scope for the merits review of administrative decisions? So when we go with this Wednes-Bury principle, all of you must be very well aware that this Wednes-Bury principle is basically the outcome of the Associated Provincial Pictures House Limited versus Wednes-Bury Corporation 1947. And one of the case which you can mention, Om Kumar versus Union of India, because this principle is an outcome of the judicial precedents only. And you can also mention about this Menka Gandhi case versus Union of India. Om Kumar case was about Article 14 violation, and this Menka Gandhi case was a violation of Article 19, 1A and G as well. So what is this Wednes-Bury principle? First of all, we should focus upon this and then we will come to the outcome. Okay, so when I just want to tell you, this doctrine of Wednes-Bury principle says one of the main important thing that what is unreasonable and what cannot be done by any reasonable person. So the administration in the name of the authority should not apply any kind of rules or regulations which are, you can say, which should not be reasonable actually. So this principle simply says the actions of the administrative authorities can be challenged on the basis of the reasonableness. So the point is, what is reasonableness actually? What is reasonableness? So basically the concept of reasonableness has been decided by the court in many of the cases. So I will just have a discussion with you about those cases only. So if you go by, one of the case was Chintaman versus State of Madhya Pradesh. In this case, court held that the ultimate purpose is to maintain a balance of the fundamental rights of the citizens and the restrictions which are being imposed. And the court has the power to basically check the constitutional validity of any legislation or any administrative decision. And in some way, we basically call this doctrine of proportionality as well. Okay, that the kind of legislation or the kind of administrative decision, whether it is really, proportional to the optimum balance or the proper balance of the fundamental rights of the citizens or not. Similarly, when you go by the Bhagatram versus State of Himachal Pradesh, in which the Supreme Court opined that if the punishment imposed is not proportional to the gravity of the offense, then it is in violation of Article 14 as well. So basically, what I just mean to say, whatever kind of administrative action administration takes, they should be proportional and they should be reasonable. If they are unreasonable, in that particular case, in the name of administrative action, you cannot save yourself. So if you go by the actual judgment of this Wednes-Bury case, in which this principle was laid down actually, it provides a standard of unreasonableness, used in assessing an application for judicial review of a public authority's decision. I repeat once again, the ultimate crux of this point is, a decision is Wednes-Bury unreasonable if it is so unreasonable that no reasonable person acting reasonably could have made it simple. So I repeat once again, in Wednesbury case, it was held, a decision is unreasonable if it is so unreasonable that no reasonable person acting reasonably could have made it. So if you go by the precedents of Indian judicial system, like for example in Maneka Gandhi case, when her passport was confiscated by the government, it was held that it is in violation of his fundamental rights, of her fundamental rights. Similarly, in case of Union of India versus G. Ganayuttam, Supreme Court held that as long as fundamental rights of the citizens are not involved, the principle of Wednesbury unreasonableness would be applied. By quoting such examples, by quoting such judgments, you have to just give the answer of this question only. Because this is only the outcome of the judicial precedents only. So, do these principles provide in any way scope of the merits review of the administrative decisions? Obviously, because when you talk about that no reasonable man can, in a reasonable manner will take this decision. So, this is obviously about the merits. So, if you go by Om Kumar versus Union of India case, Supreme Court has recognized in Indian context this proportionality test because it is actually about the proportionality. Okay. So, in deciding the legitimacy of the legislation, if they violate any of the fundamental rights guaranteed under Article 14, 1921 of the Indian Constitution, and actually it is mainly concerned with the administrative action only. Okay, so what you can say, if any administrative action is in violation of the fundamental rights, so that should be referred to the court for the judicial review for the number one. And Supreme Court held in Om Kumar case that in case of discriminatory or arbitrary administrative decisions violative of Article 14, I repeat this line once again, the Supreme Court held in Om Kumar case that in case of discriminatory or arbitrary administrative decisions, if they are violative of Article 14, so the primary review would be carried out on the basis of the proportionality doctrine, whereas secondary review would be carried out on the basis of the Wednesbury unreasonableness principle. So when we talk about this proportionality and the Wednesbury principle, so first of all of you should be having an idea that Wednesbury principle and the doctrine of proportionality, how they are related with each other actually. Okay, so first of all, principle of Wednesbury unreasonableness. So this principle simply provides, sometimes we basically, correlate these two doctrines with each other, but there is a very thin line of difference actually. So the Wednesbury principle simply provides that, the discretion that has been conferred upon the administration should be exercised properly and reasonably in accordance with law. So whenever any power has been given to the administration, that should be exercised properly and reasonably in accordance with the law, number one. And when we talk about the proportionality, it simply says the decisions and the orders of the administration should only be restrictive as absolute necessary for public purpose. So the point of, the Wednesbury and the proportionality test, the proportionality doctrine has objective criteria for analysis. What is the purpose of the government to enact or to take such decision? While the purpose of this Wednesbury principle is basically this simply provides that the decision of the administrative machinery should be reasonable in a given situation. Okay, which a reasonable man can apply. Otherwise, that decision will become void. This kind of decision will not be valid. So, when we talk about this, you can say, Wednesbury principle and this proportionality test actually. So, what we can conclude actually In this Om Kumar case, as I mentioned you, when prima facie it is in violation of the fundamental rights, so generally we apply the proportionality test because we have to figure out the objective, and then basically in a secondary review will be carried out whether this particular action is reasonable as per the reasonable man or not. So this gives you an idea how you should mention about this Wednesbury principle and little bit about, you can say, the proportionality test as well, because somehow they are applied in a same sequence actually. And do these principles provide in any way scope for the merits review? So basically, when we talk about the reasonable man, in a reasonable way, so in many of the cases, Supreme Court has applied they have reviewed the merits of the case as well, but that is through the proportionality test actually. So they are somehow related with each other. So this proportionality test and the Wednesbury principle, you should mention both actually in this case. Okay. So moving further now, question number 2, part A, which is about the amending power does not extend to the damaging or destroying the basic structure or framework of our constitution. This question, I hope every UPSC aspirant is very well aware of, because in this question, we are talking about the amending powers of the constitution, of the parliament actually, and the relationship of amending power with the basic structure, whereby you can mention Shankari Prasad case, first of all, 1951, Shankari Prasad versus Union of India, and Sajjan Singh versus State of Rajasthan, 1965, in which Supreme Court held that the Parliament has the absolute power to change or to amend the constitution. So these were the two cases which were applied by the the Supreme Court. In these two cases, Supreme Court actually focused about this Shankari Prasad and Sajjan Singh case. Supreme Court has said that actually at the time the idea or the mind of the Supreme Court was that this elected government is properly representing the nation and they will not make any adverse decision. But later on, we all know very well what happened later on. In Golaknath case, the issue came in Golaknath case versus State of Punjab, 1967, in which Supreme Court actually overruled these two judgments, and they said that fundamental rights are supreme. They cannot be taken away by the Parliament. So to counter this judgment of the Supreme Court, Indira Gandhi government, she brought in 1970 many of the amendments, and more specifically 24th Amendment, 24th, 25th Amendments, etc. So they are basically, you can say, the amendments, 24th Amendment, 25th, 26th and 29th Amendment, due to which there were a lot of controversy, and finally in Keshwanand Bharti case, Supreme Court finally held about the basic structure doctrine. However, this basic structure concept was laid down in Sajjan Singh case by Justice Mudholkar. So Justice Mudholkar has actually propounded this basic structure theory, but ultimately this concept was recognized by the Supreme Court in Keshwanand Bharti case, which clearly said that the Parliament has the power to amend anything, but that should be within the purview of the basic structure of the Constitution. So that cannot be interfered by the Parliament at any cost. So you are supposed to just mention these cases and just conclude about the ultimate amending power of the Parliament. Simple. So the extent of the damaging or destroying the basic structure or the framework of our Constitution. So by these judgments, you will simply conclude your arguments. Okay. Now coming to another question, discuss the application of the fundamental rights to parliamentary privileges. We all know very well the kind of parliamentary privileges actually. So basically, when we talk about the parliamentary privileges, so recently we have seen, like in 2019, the Speaker of Maharashtra Legislative Assembly, who ordered the arrest of a man who made a parody video of a speech made by the member of Legislative Assembly of the government. The arrest order, when they were initiated against him, and it was stated that he had violated the parliamentary privileges of the members of parliament. Okay, also, before that we have seen that the chief of Maharashtra Dance Bar Association was given imprisonment for 90 days for using a remark. The remark was, we would not allow ministers' wives to move around if dance bars were banned. So the Legislative Assembly said that it is a breach of parliamentary privilege. And same kind of scenes we have seen in Bangalore as well, in Karnataka actually, and even in Tamil Nadu as well. Even in case of Kangana Ranawat as well, she was summoned. Okay. So the point here is why this question is relevant and what are the various judgments to take care that, the conflict between the fundamental rights and the parliamentary privileges. So discuss the application of fundamental rights to the parliamentary privileges cases. So sometimes there is a conflict between the fundamental rights and the parliamentary privileges. So when you talk about the parliamentary privileges, all of you know very well that Article 105 and Article 194. So first of all, you should be very well aware that which articles are relevant for you. So Article 105, which is about the powers of the parliamentarians, and Article 194 about the powers of the state legislatures, the privileges actually. Okay. So the Article 105 simply says, subject to the provisions of the Constitution of India and the rules and standing orders regarding the procedure of the Parliament, there shall be freedom of speech in the Parliament. So this article actually gives absolute immunity from the courts for anything that is being said during the course of the proceedings of the House or its committees. The member of parliaments, they are, you can say, they are prohibited to repeat or publish any defamatory speech, but whatever they say in the parliament, they are absolutely immune from any action actually. But if they repeat or publish any such defamatory speech given in the parliament, then they are liable under IPC section 500 for the defamation. So basically Article 105 and further Article 105 clause 2, which talks about the right of publication of its proceedings with the parliamentarians. So this particular, you can say, parliamentary privileges talks about the various rights available with the parliamentarians, the parliamentary privileges actually. So first parliamentary privileges, we have the freedom of speech in the parliament and the legislature of each state with the parliamentarians and the legislatures. Then right of publication of its proceedings under Article 105 clause 2. Then we have right to exclude strangers from the proceedings of the parliament and hold secret sessions as well. Then the right to regulate the internal proceedings, right to punish the members or outsiders for the contempt. It is also one of the issue because there is a conflict of the Article 19(1)(a) along with this Article 105. So the cases which I mentioned you, those cases are concerned with this particular point whereby parliamentarians basically in the name of the contempt, they sometimes bring action against the citizens. So this, the main area of conflict between the fundamental rights and the parliamentary privileges is basically the parliamentary privileges. They state that the members in the parliament, they have the right to prohibit. Okay, I just continue this and then I will just come to the main point actually, the reason of conflict actually. The reason is if there is, this particular point of Parliamentary Privileges, which gives the members a right to prohibit publication of proceedings and reports in their respective sessions, and the freedom of press and speech. So, this comes in conflict with the fundamental right of freedom of speech and expression, which states that it is a right guaranteed to the express one's convictions and opinions freely by words of mouth, writing or printing or pictures or by any other mode. And parliamentary privileges are referred as independent rights, and they do not have any reasonable restrictions as well. But other fundamental rights given to the persons, given to the citizens, they are subject to the reasonable restrictions as well. So in this case, we can refer few judgments, like for example, G.K. Reddy versus Union of India. In this case, 1954, this case is of 1954. In this case, I just simply mention few cases only, and if you are aware about any other case, you can just mention it down. In G.K. Reddy versus Union of India case, a writ petition was filed under Article 32 to the before the Supreme Court, praying that the G.K. Reddy, the editor of the magazine, who was held for the contempt of a privilege, a parliamentary privilege, and he was under the illegal detention. The petition said that he was arrested in Bombay and was taken into custody by the Lucknow police and was produced before the UP speaker to answer a charge of breach of privilege. The journalist was not even produced before the magistrate within 24 hours of the arrest, and he was kept under the illegal detention under the custody of the Speaker of the Legislative Assembly of the UP. So when this petition was filed under Article 32 before the Supreme Court held that failure to produce the arrested person before the magistrate within 24 hours amounts to illegal arrest, and it is in grave violation of a right guaranteed under Article 22 Clause 2 of the Constitution. So basically, the application of the fundamental rights to the parliamentary privilege, we have to just maintain a proper balance between the kind of parliamentary privileges and the fundamental rights. So in the name of the absolute kind of freedom, like for example in civil matters, the parliamentarians basically they are immune for first 40 days and another 40 days kind of criteria they have. So even in case of criminal proceedings, however they are not immune for criminal proceedings, but for civil proceedings they are immune for certain time period. Like when the parliament is in session or is going to start, so before 40 days and after the 40 days of the session, they cannot be, arrested. But in criminal proceedings, they are not immune. Even the the vice president has mentioned also that the MPs, MLAs, they are not immune from the criminal jurisdiction of this country. Okay, there are a number of cases whereby such kind of, power has been misused. Another case you can refer this Keshav Singh versus Legislative Assembly, okay, of UP. Basically, he was also arrested. Who was not a member of UP Assembly, the Keshav Singh. He was held guilty for contempt of the House, and he was sentenced for the imprisonment for 7 days. So in this case, Allahabad High Court gave the bail to this petitioner, and finally, when the matter went before the Supreme Court, it was held that by the court that the judges were not guilty of committing contempt of the House by issuance of an interim bail, because the matter was, taken against the judge himself, by the judge, against the judge only. Okay. So the assembly, aggrieved by the decision of the court, they passed a resolution that the judges and Keshav Singh and his advocate, they have committed the contempt of the House and should be taken into custody. So now you can understand how this parliamentary privileges is being sometimes used in violating the fundamental rights of the citizens of this country. And this question has come in the UP this time because in the recent past, we have seen number of cases whereby number of persons were summoned by the state legislative assemblies or by the parliament as well. Many a times we have seen this. Okay, even this matter you can also refer that whether parliamentary privileges are supreme or the fundamental right. So this kind of decision or conclusion you can just mention over here. Okay. After this, we have another question. Do you think that all the directive principles of the state policy are equally fundamental for the governance of the country described with the help of the decided case laws? One of the main and the most important question which all of you can find every year you can find this kind of question. And in this case, we can mention few landmark cases. I just mentioned the cases only. Rest you can relate. Like for example, Uni Krishnan versus state of Andhra Pradesh. Okay, this is one of the case whereby Article 45 and Article, you can say this 21A, later on basically after some time, no doubt, right to education of 6 to 14 years of age of the child, because it was recognized in this case that right to education should be given to the child, okay, to the children. Then Randhir Singh case. Randhir Singh versus Union of India, 1982. Equal pay, equal work. The concept given, you can say Article 39D and the relationship with Article 14 and 16. And another case you can also refer in the same dimension. Greg Kalyan, Kendra Workers Union, Greg Kalyan, Kendra Workers Union versus Union of India, 1991, whereby the same kind of matter was there about equal pay, equal work. And another case you can mention, H.M. Hoskote versus State of Maharashtra, 1978, in which right to legal aid and speedy justice, Article 39A and Article 21 relationship. So by this way you can understand how the articles of DPSP, Article 45 with Article 21A, Article 39D with Article 14 and 16, Article 39A with Article 21, they are correlated. So as I mentioned you, even in our classroom programs, we have already mentioned to all our candidates that DPSPs are not, they normally are seen in conflict with the fundamental rights, but it is not the real picture, it is not the real scenario. Basically, they are supplementary and complementary to each other. And few words you can mention that DPSP, they serve as a guiding light. They serve as a purpose of guiding light to the fundamental rights and to the governance of the country. Okay. Similarly, you can mention this symbolizes, the DPSP symbolizes the welfare state and they provide social and economic justice as well, because ultimate purpose is basically governance of the country with the DPSP and then case laws. So case laws I have mentioned over here. Rest, if you remember any other case, you can mention as well. Then the moral obligation, because the DPSP, they create public opinion, and that is the reason if the state government, if the government is not basically, doing its duty, then the ultimate sanctioning power is not legal but political one. Next, elections. This is one of the points which you should mention. So ultimately you can mention these few words and conclude your answer. Simple, nothing else. Then can the constitutional head of the state be truly described as the nerve center of the federal system? Explain the light of the powers and duties of the governor. Simple, very, very, very simple question. And then criticize the role of the government. Because we have seen many times that the governor is being considered as the rubber stamp of the central government. So basically, article, you can say, 163, which talks about that governor should exercise his functions based on the State Council of Ministers' aid and advice. So in this particular question, what you are supposed to mention, because first the initial starting point of this question is the various rights and duties, powers and duties of the governor. So first of all, start mentioning about the powers and the duties of the governor. Okay, so once you start mentioning about the powers and duties of the governor, that you can just easily mention, because all of you have covered this particular, you can say, question in your Indian Polity by M. Lakshmikant. So by simply referring the relevant articles or the relevant provisions, like for example article 153 you can quote, article 155 you can quote, which basically about the governor and the appointment of governor, and then you can mention about the various powers available with the governor. Okay, so the powers and functions you can categorize in executive, legislative, even financial, judicial, pardoning power, ordinance power. Just mention a little bit about these powers of the governor, one by very specifically. And few cases you can also mention whereby, like Ram Javaya Kapoor versus state of Punjab, whereby Supreme Court held that president and the governors are the constitutional heads, and the real executive power is with the Council of Ministers. Similarly, you can also mention the Shamsher Singh versus State of Punjab case as well, 1974, whereby once again same thing was held by the Supreme Court. So by this way, you can mention first of all the powers of the governor, the kind of the powers governor has with himself, and then you can mention about the duties of the governor, the role of the governor, you can say. And after that, you have to mention about the issues with respect to the governor in Indian constitution, in Indian scenario. And then try to mention the solution thereof. Because the ultimate point you should relate with the, the nerve center of the federal system. So in this way, you have to just simply mention the various powers and the duties of the governor, and then try to conclude why governor is necessary. Why governor is necessary. So you can also mention the S.R. Bomai judgment as well, Rameshwar Prasad case also you can mention, and this number ABA judgment as well you can mention. If you are aware about these judgments, then it is okay. If you are not, then please go through these judgments. And also try to figure out why, governor is necessary. Why this governor is necessary. In Har Govind Pant versus Dr. Raghukul Tilak case, Supreme Court held that governor is the head of the state and a high constitutional office he holds, and he cannot be regarded as the employee or servant of the government of India, number one. And when we talk about the governor, no doubt we know very well that governor is generally appointed by the central government, but the main reason or the importance of the post of the governor, which you should mention to just justify the nerve center of the federal system. I'm just mentioning few points, rest you can write down from your side. Under this constitutional scheme, governor mandate is, first of all, overseeing the government functions. Whether the government, state government is functioning as per the mandate of the constitution or not, that is one of the biggest functions. Because the kind of quasi-federal system we have in our country, because we are not a country like USA, whereby the states, they come together for their common purpose. In India, we come together not by choice, but because of the circumstances. So that is the reason we do require some kind of force by which the unity and integrity of this country can be maintained. No doubt, sometimes we can figure out the misuse of the power, but that is subject to the judicial review as well, that we cannot forget. Then, if the constitutional machinery is not working, then reporting to the union government is one of the biggest duty. And governor maintains the chain of command and the effective communication between the central and the state government. And along with this, you know very well that governor has the power to reserve the bills for the assent. In case of emergency, he has the power to promulgate the ordinances as well when the legislature is not in session. So basically, as a head, as a nerve center, governor ensures the continuance of the governance in the state, even in times of constitutional crisis. His role is basically to work as a neutral arbiter in disputes. So by this way, governor ensures that proper constitutional mandate of the country is maintained. That is one of the main crucial points which all of you should mention. Okay. Then comes briefly discuss the impact of the proclamation of emergency under Article 352 of the Constitution. So I don't think so that you require the answer of this question as well, because this question is very straightforward, whereby you have to just mention about Article 352. And you know very well this Article 352, which is about, you can say, national emergency. When this national emergency can be declared, what are the grounds of national emergency, and then the kind of the further parameters of continuation of this emergency. So in this question, basically you can start by writing the national emergency under Article 352, the grounds of declaration, basically on the basis of the war, external aggression, or armed rebellion. Okay, these points you should mention to just explain what is this emergency actually is all about, and then the parliamentary approval you require. Okay, so basically about national emergency, a simple topic which all of you should have covered from your Indian polity M. Lakshmikant. That is, that is the only thing which you should mention. Nothing from my side to explain basically in this kind of question. So by looking at this kind of question, you can figure out that in UPSC, it is very easy for you to attempt law optional very easily, because many of the things you have already covered in GS, General Studies paper, okay. So instead of going into this Article 352, which all of you are very well aware, so no need of, because it is a very static kind of question. Okay, so moving forward. In the parliamentary system, though there is no separation between the legislature and the executive in terms of personnel, there is separation of functions between the two. Separation of functions. Explain in light of the relevant decisions. So you know very well that, in our country, the kind of federal system we follow, we do not have separation of personals. Like for example, All India Services, you can quote this in your example. Okay, the judiciary, because we have the common, when we go to the high courts or supreme courts, the judges are being appointed in uniform basis. No doubt in our judiciary, the pattern of appointment of the judges as per the state government discretion. But at national level, at Supreme Court level, at High Court level, it is with respect to the, you can say, no differentiation of the personals, but it is basically on the basis of the complete, on country basis actually. So you just mention about the kind of separation of the functions between the state government and the central government. Okay, and you can mention about the legislature, how this legislative kind of function is divided between the state government and the central government, then the executive functions and the judiciary function, the three-tier machinery of the government actually. Okay, and then start mentioning about the constitutional status of this bifurcation of the power. So you know very well that when we talk about the separation of the functions as such, we can refer Article 62 till Article 72. whereby we talk about the functions and powers of the president with respect to this country overall. Then we know very well that judiciary is self-dependent or independent. Basically, there is no obstruction of the legislature or the executive. Okay, then you can also mention about the kind of powers which Supreme Court or High Courts can exercise under Article 32 or Article 226 or 227 as well, or Article 136 as well, judicial review. Okay, so the point is the doctrine of separation of power, we can consider this in two sense. One in rigid sense and one is broad sense. When we go with the rigid sense, we can say when there is a proper distinction, proper differentiation between all these organs and their functions, and when there is a proper system of checks and balances as well. And doctrine of separation of power in broader sense, basically, when there is no proper distinction between the organs and their functions. So what I mean to say, in this kind of question, you have to basically a little bit kind of very smart. Like for example, in Golaknath versus State of Punjab case, the Indira Gandhi and Rajnarayan case, Indira Gandhi versus Rajnarayan case, and the Ram Javaya Kapoor versus State of Punjab case as well. And another, you can say, like the articles which you can mention about the separation of the powers between the central and the state government, like Article 50, Article 105, Article 123, Article 74, okay, 368 as well. So, what actually is the status of this bifurcation or the separation of powers in our country? If you go by the Golaknath case, because in the question they have mentioned about the the relevant judicial decisions as well. So you should be aware about these decisions mainly. So in Golaknath case, Supreme Court held the constitution brings actually the distinct constitutional entities, union territories, that is union and state, you can say. Then major instruments like judiciary, executive, legislature. Constitution demarcates their jurisdiction very minutely and expect them to exercise their function without interfering with the function of others. So they should function within their own scope. So if we go through this constitutional provision, what we can say that the doctrine of separation of power has not been accepted in the rigid sense, but it is a combination of rigid sense as well as a broader sense as well. Okay. So, in Indira Gandhi and Rajnarayan case as well, court held that in our constitution, the doctrine of separation of power has accepted in a broader sense. So, the rigid sense of separation of power, because in our case, we have quasi-federal nature of our constitution, our country, whereby at one point of time there is a separation of power, while in case of emergency, in case of some other issue, it is unitary as well. So at some point of time it is federal, it seems to be federal, at another time it seems to be unitary. So in such a case, you have to just mention that what are the various, the features or the various parameters of the separation of powers between the central and the state government. So by this way, you can just conclude. And then also you can mention the Ram Javaya Kapoor versus State of Punjab case, whereby Justice Mukherjee had observed that India, the doctrine has not been accepted in the rigid sense, but the functions of all three organs have been differentiated. And it can be said that our constitution has not been a deliberate assumption that functions of one organ belong to another. It can be said that through this practice is accepted in India, but not in a strict sense. There is no provision in Indian constitution which talks about the separation of power except Article 50, which talks about the separation of executive from the judiciary. But this doctrine in practice in India, all three organs interfere with each other functions whenever necessary. Whenever necessary. They work in isolation, but they interfere whenever necessary. So you can just try to conclude this by this wording, because this wording is very crucial in this case. Okay, guys. Now moving towards another question. Are administrative tribunals competent to examine the constitutional validity of the primary legislations? Discuss in the light of the case laws. This is one of the, you can say, this question basically originates from one of the landmark judgment actually. And this judgment we generally know in the name of L. Chandra Kumar case. L. Chandra Kumar case. In L. Chandra Kumar case, there were three issues before the Supreme Court, which was about the constitutional legality of the tribunals actually. So, in L. Chandra Kumar case, it was before the Supreme Court to decide whether it is possible to say that the tribunals established and operating under the Act are effective substitutes for the High Courts in exercising the power of judicial review. Because if you see in many of the cases, sometimes after tribunal, you can directly go to the Supreme Court. Okay, so the question was whether this substitute of High Court in the name of tribunals is subject matter of judicial review or not. If not, then what changes must be made to bring the tribunals into compliance with their objectives? The main question was, is it true that the tribunals have the authority to examine the constitutional legality of the statutory rules enacted under Article 323A and Article 323B of the Indian Constitution? So if you refer this Article 323A and Article 323B, basically they empower the Parliament to create tribunals. Okay, and Article 323B, it basically allowed the Parliament and the state legislatures both to create tribunals. So the ultimate question which is being asked by the UPSC is mainly about when they are talking about the primary legislation. So through the law by which the tribunals are created, whether they have the competence to examine that validity of the primary legislation by which they have been created or not, that is the question of discussion in this question actually. So if you go by the L. Chandra Kumar case, you will get the answers of each and every question. So in this case actually, the question is whether the tribunals have the authority to examine the constitutional legality of the statutory rules enacted under Article 323A or B of the Indian Constitution, which is about the creation of the tribunal themselves. So if you refer the judgment, the outcome of this L. Chandra Kumar case, the outcome is tribunals cannot serve as a substitute for the High Court's judicial review. Okay. Tribunals can be supervised by the High Courts and they cannot be considered as the independent organization. This is one of the outcomes I'm just mentioning you. Main outcome which we should be focusing upon, that whether they have the power to review this primary legislation or not. So basically, it was held in this case, I am reading about the judgment of this L. Chandra Kumar case. The fact that tribunals are supervised by the Supreme Court and High Court, also you can say part of the constitutional core framework. So the High Court and the Supreme Court cannot be excluded from the judicial review of the legislative action taken in exercise of the power by the tribunals. And another main point, which is about the question actually. Tribunals established under Article 323A and 323B have the authority to investigate the legality of, they have the authority to investigate the legality of the subordinate legislation, but they are not permitted to investigate the legality of their parent laws. Means, under this L. Chandra Kumar case, it was categorically mentioned by the court that they have the authority to investigate the legality of the subordinate legislation. They have the authority to check the subordinate legislation. But they do not have the authority to investigate the legality of their parent laws. So under Article 226 or 227, all tribunal rulings would be reviewed by a division bench of their respective high courts. And Article 136 prohibit a direct appeal to the Supreme Court. Okay. So what we can say, if we go by the L. Chandra Kumar case in total, if you just mention this judgment only, no need of going for any other thing else. Just L. Chandra Kumar case will be sufficient for this answer. Okay. Now coming to the next point, explain the significance of odi alteram partem and what are the exceptions basically. What are the cases or circumstances in which the aforesaid principle of natural justice can be excluded. Okay. So if you go by this odi alteram partem, I think all of you are very well aware what is this odi alteram partem rule. It is a rule of, you can say, the natural justice, whereby party should be given the right to be heard. Means a party should be given to present himself, present his arguments, present his side of defense. And it is one of the, you can say, rule of the natural justice. So we have two kind of rules of natural justice. One is nemo judex in causa sua. No one can be a judge in his own case. And odi alteram partem means everyone should be given a fair chance to be heard. So first explain what is odi alteram partem. First try to explain what is this, the principle of natural justice basically. And then try to explain the exceptions basically. We have been given certain exceptions which I will just tell you. Like the exception, or you can say the doctrine of necessity and absolute necessity. So in doctrine of necessity and absolute necessity, we have been given a judgment called Ashok Kumar Yadav versus State of Haryana. Doctrine of necessity. So basically, in this Ashok Kumar Yadav versus State of Haryana case, it was held by the court that a member of Public Service Commission cannot exclude himself from the selection process completely, just because they might be related to some of the candidates, and may exclude themselves only during the selection process of those candidates to whom he might be related. So basically this doctrine says that in such a case, when we talk about the right to be heard, so if a person is having some kind of relationship with another person, so that person might be excluded from the ambit of that particular, you can say, interview process. It is basically about, you can say, the principle of natural justice. Also, in case of emergency as well, like Mohinder Singh Gill versus Chief Election Commission, whereby the elections were going on in Firozpur and which were interrupted by the mob violence, and the ballot papers and the boxes were destroyed. So the Election Commission of India ignored the right to be heard, and without any notice, Election Commission of India gave the order for the re-election. So in this case, Supreme Court held that in exceptional cases, in case of emergency, such kind of decisions are allowed even when they have not gone for the odi alteram partem to the other party as well. Another exception, you can say, when there is no right of an individual has been infringed. If there is no right of infringement of any individual has taken place, then also, like in J.R. Vora versus Indian Export House Private Limited. J.R. Vora versus Indian Export House Private Limited case, whereby there was no impact upon the rights of an individual, and it was held that it does not amount to the, you can say, the violation of the odi alteram partem rule, whereby the Delhi Rent Control Act was basically into question. Okay, a matter was about the Delhi Rent Control Act actually. Then in case of when the public interest is of utmost importance, whereby the Balco Employees Union versus Union of India case is there, when public interest is more important in such a case. So you can just quote such kind of cases or examples in support of your answer, and in this way your answer will be complete. So this you can say is about the part A of the constitutional and administrative law. And the second part starts with this public international law. Okay. So just give me a minute only. I will just continue this discussion. Just give me a minute only. Now guys, coming to this international law, and this is one of the interesting subject which all of you. So first of all, starting with this number one, the question is, keeping in view the growth of international law in the contemporary era, do you think the classical definition of international law has been redundant? Basically, in this case, you have to just mention about the contemporary phenomena or the growth of, first of all, just try to figure out the growth of international law. So that you can mention like the historical context of the growth of international law. So in case of international law, we have been given that how this system of international law evolved over the time, like the classical era and then modern era, medieval era as well. We have been given, three kind of stages actually. So I discussed this international law in three phases: classical era, then medieval era, and then the modern era. And then after the Second World War, the kind of new system we have in this world. And you can quote any of the definition of any of the person, the classical definitions, okay, over here, of any of the person. And then you can just try to figure out how this definition of international law has become redundant. Because ultimately in the classical period, the definition given by the few persons, like for example, you can say I just quote you few of the definition, and then you can conclude what is this, whether this definition is really applicable in this current scenario or not. Like for example, the Austin, Hobbes, even Hugo Grotius, who was considered as the father of international law. So these persons have given the definition of international law by saying that international law is, I just mention you specifically the definition of Oppenheim. If you refer this definition of Oppenheim, Oppenheim said the international law just give me a minute only. As per Oppenheim, international law is the law of the nations, or international law is the name for the body of the customary and conventional rules which are considered legally binding by the civilized state in their intercourse with each other. Further, as per Torsten, he said that international law means the body of the rules of law which apply within the international community or society of states. J.L. Brierley had said that international law is the body of rules and principle of action which are binding upon civilized nations in their relations with one another. So, if we go by the contemporary era, I do not think that the classical definition has become redundant, because ultimately in all these definitions, like Oppenheim, The main idea of international law is it is the kind of relationship among the nations, among the states, and more specifically, the body of rules and principles of action, or you can say the body of rules of law which apply in international community because of the relationship of one with another. That is one of the criteria actually. So the classical definitions are still applicable as per my view. Your view might be different. So you just quote few of the definition of Oppenheimer or Bradley only, and then mention about the growth of international law, and then try to conclude whether those definitions are still applicable or not. But as per my view, those definitions are still applicable because in international law, the ultimate criteria is mutual interest actually. I used to say only one thing: there are no friends, no enemies in international scenario. It is only the mutual interest. So everything is based upon mutual interest. Even the social contract theory or the consent theory, which are the basis of international law, or the concept of, you can say, pacta sunt servanda, all these things, they find the importance of international law through, you can say, mutual interest only. So the social, political or economic interest only serve the main purpose of, you can say, having this international law as a law. And these are the only things which make this law a little bit binding upon the states. Because when we talk about the pacta sunt servanda, we say the promises must be kept. So promises must be kept means we should adhere or we should follow our obligations accordingly, because we are living in a society. So I don't think so that those definitions have become redundant, because still international law has, you can say, value because of the mutual interests only, nothing else. Okay. Moving further, distinguish between the de facto and the de jure recognition. First of all, what is recognition? So whenever any new state emerges, so whether the other state should recognize that state or not, or recognition can be of the state or the government. Like for example, when we have seen that in case of Afghanistan, there was change in government. So whether this new government should be recognized by the India or not. Like for example, when Kosovo was created out of Serbia, so whether Kosovo should be recognized by India or not. So what is this recognition? For this recognition, we should have first understanding about the elements of the statehood. So you first start mentioning about the elements of statehood, then come to the importance of recognition, why recognition is important, and then how recognition is being given. Okay, and you can also mention two kind of theories as well. One is declaratory theory, other one is the constitutive theory. There are two theories as well about this recognition. Then de facto and de jure, it simply means when it is basically given as a temporary kind of recognition, while it is basically in permanence, nature of permanence. So once you are sure that this particular new country or new government will continue properly or will adhere to the international norms of the society, we can say yes, they are fully recognized. Like it is just like, for example, if you come across with a new neighbor of yours, if any person comes as a neighbor of yours, you cannot ignore that neighbor. Whether you build better relation with that neighbor or not, it is your choice. But in the name of, you can say, recognition, you cannot say that I do not recognize him. It is your choice. If you build better relation, he will also give you some kind of benefits only. But if you do not maintain the relation, then obviously it is the, you can say, only you are at stake. So if both of you are having, if you both of you wants to have better relationship, better interest, then obviously you should recognize the other new state or the government. Otherwise, it is purely a choice of that government or that state. Like for example, in Afghanistan, when the new government, that is Taliban, came into power, so government of India has taken very precautionary approach. We have not recognized Taliban at the very same time. Slowly, we are basically starting, building up relationship with this government, because we cannot deny this fact that Taliban is the new government in Afghanistan now. So this is the way. So basically, it is given for the temporary purpose. It is mainly for the permanence. So generally, for the time being, you basically follow the wait and watch policy. So this is de facto recognition actually. Okay. So by this way, by mentioning all these elements, you can just simply conclude this question in 150 words only. Simple. What are the territorial asylum and extraterritorial asylum? In this case, you can also mention the asylum case as well. The case between the Colombia and Peru. Okay. And when you are giving, first of all, explain asylum. What is asylum? Then explain territorial asylum. And then explain extraterritorial asylum. And then explain the asylum case. Colombia versus Peru. That's all, nothing else. So what is asylum? When you are giving protection to the offender of any other country, in your territory, this we call territorial asylum. But when you are giving asylum to the person in the territory of some other country, that is, for example, you are giving asylum to any person in your embassy in that country. Like, for example, Edward Snowden or this WikiLeaks founder Julian Assange, when they were given asylum in other countries, but not in their territory, first of all in their, you can say, embassy. So this is the case, you can say, a case of extraterritorial asylum. So simply just mention, because it is just a static part, only static part, nothing else. Only static portion, you can say. Okay. Then we have various rights of states over the territorial water or territorial sea, you can say. So right of the states. So states can be of two types. First of all, territorial sea, you know very well that you get a 12 nautical miles area. 12 nautical miles area as territorial sea. As territorial sea. So in this territorial sea, the coastal state has few rights and other states have few rights. Other states have a right of innocent passage. Right of innocent passage. Just explain this. And this innocent passage can be regulated by the coastal state. Like, for example, providing sea lanes, managing traffic. Okay, so these kind of regulations coastal state can make, but they cannot stop the other states from this right of innocent passage. What is innocent? When it is continuous and expeditious. So this we call right of innocent passage. So you are supposed to just, it is just also one static kind of question. First, start explaining the territory, what is territorial sea, and what are the rights of the coastal state and what are the rights of the other states. In other states, the main right is right of innocent passage. Please explain right of innocent passage very clearly. And then come to the rights of coastal state. Simple, that's all, nothing else. Distinguish between the arbitration and the judicial settlement as methods of the peaceful settlement of disputes in international law. When we talk about the arbitration, we talk about the Permanent Court of Arbitration. And when we talk about the judicial settlement, we talk about the ICJ, International Court of Justice. So Permanent Court of Arbitration and International Court of Justice, explanation first. What is Permanent Court of Arbitration? How exactly this works? And you can quote an example as well. Like, for example, recently the Enrica Lexi case was taken care by Permanent Court of Arbitration. Okay, so you can just quote what is PCA and how exactly it works, and you can quote this judgment as well. Then you can also quote the functioning of ICJ, how exactly it works, what are the various, you can say, the kind of jurisdiction ICJ has, jurisdiction. And finally, you can quote few cases, like you can also mention Kulbhushan Jadhav case as well. By this way, this answer will be complete, nothing else. So this is also a static question. So by going through this kind of discussion, you can understand how exactly UPSC is asking questions. So you are supposed to just have a basic idea. In our classroom, basically we teach all these things, and even if you go by the kind of mock test, you can simply figure out that all these questions we ask in our test series. Okay. So this is one of the points which all of you should be concerned with. Okay. International law is one of the easiest subject in case of this law optional. Please mind this thing. Critically examine various theories relating to the relationship between international law and municipal law. Again, one of the easiest question. Whether international law is separate from municipal law or whether municipal law and international law both are same. In this case, we normally follow monism theory and dualism theory. So there are the two theories actually. You have to just explain. Monism theory say they both are same. They both are same, but they just regulate, different kind of subject matters. While dualism says no, they are different. They are different. So this entire discussion revolves around monism and dualism. So I advise all of you, please go through this theory and your answer will be complete, nothing else. So start getting an idea what is monism theory and what is dualism theory. In monism theory, they say first it is international law which is superior than municipal law. And municipal law is under the, you can say, delegation of international law. While dualism theory says no, municipal law is superior because it is having sanctioning power. And international law is a weak law because it doesn't have any sanctioning power as such. That is the reason, and both they operate in a separate set of circumstances, separately. They do not have any kind of relationship with each other. So by this way, you can simply conclude what is monism theory and what is dualism theory. Simple, nothing else. No need of, it is also one of the static part of the question. Simple. Further, we have various theories of the state succession. State succession. When we talk about the state succession, we have to just understand what is state succession first, and then what are the various theories of state succession. So state succession means, like for example, whenever any new state emerges, okay, or in other words, you can say, first of all, try to explain what is state succession. In case of, like for example, USSR, when USSR got disintegrated, so the new states which came into picture, or after the independence of India, Pakistan became a new state. So this we call state succession actually. So generally what happens, when due to merging or due to separation, when new states come into picture, then the main question is what is the ultimate liability of the new state or the old state. Like for example, at the time of independence, when India and Pakistan, they got partition, India got partitioned. So when Pakistan became a new state, we applied clean state theory. It means Pakistan was not having any kind of liability. Pakistan only got finance from India, no liability. Every liability was incurred and faced by India only. So this is one of the theory of, you can say, state succession. So we have been given different theories actually. One is universal succession theory. Universal succession theory. We have been given popular continuity theory. We have been given organic substitution theory. Further, we have been given negative theory. Further, we have been given communist theory as well. I give you basic idea about these theories one by one. First of all, when we talk about the universal succession theory, it is one of the oldest theory of the succession given by the Hugo Grotius, who said the predecessor state pass on to the new state, means the successor state upon succession without any exception and modification. As per this theory, rights and duties of the old state pass on to the new state. It is universal theory. Like for example, if take an example of Germany. East Germany, West Germany, when they merged together and the new state came into picture, Germany. So this Germany was having all rights and duties of the East and West Germany together. This we call universal succession theory. Okay, similarly, we have been given popular continuity theory. This popular continuity theory simply says it is just another version of the universal theory actually, given by Feuer and Fredier, who said that upon succession, only the political personality gets changed. State remain as it is. And if state remains as it is, only the political change in the country or the state does not amount to the change. It is only just a continuation, nothing else. Simple. Then similarly, we have been given organic substitution theory. In this theory, you can say it was held that rights and duties of the state continue even after succession by another state. So, for example, after the, you can say, this creation of Bangladesh. So, when Bangladesh was created, so Bangladesh presumed all rights and duties of the earlier, you can say, East Pakistan. And similarly, generally the theories are simply the guiding factor to tell you how exactly succession is applied. Like, for example, it is just like when a person dies, who will get the property of that person, the succession of the property. Same thing is applicable over here. Whenever any new state comes into picture, that new state may be because of partition, maybe because of unification, maybe because of disintegration. So whenever new state comes into picture, what should be the ultimately, you can say, outcome? What should happen with the rights and duties of the old state with the new state? Like, for example, when the disintegration of USSR took place, the main question was, who shall bear the duties of the USSR? So it was divided equally among all new states. This is, you can say, succession. So these theories basically try to explain the various methods or the various ways by which rights and duties of the old setup of the state are continued with the new state. Simple. So just try to write down these theories only, okay? Rest you can just go through that and simply just write down this answer within, you can say, as a 15 marker question only. Discuss various modes of acquisition and loss of the nationality. It is just like the citizenship. The way you can acquire the citizenship, because nationality is a concept of international law, while citizenship is a concern of municipal law. Because as a citizen, you get few rights and duties in your country. That is the reason it is your municipal matter, municipal law. While when you operate at international level, so you are not figured out from the citizenship, but you are figured out through the nationality. So if you go by the nationality concept, you please simply refer, nothing else, just simply refer the kind of citizenship, the citizenship parameters. How do you acquire citizenship in our country? Just mention those provisions only. Like, for example, if I talk about the citizenship in our country, the acquisition of citizenship in our country by birth, by descent, by incorporation of territory, by registration, by naturalization, or by special provisions under the Assam Accord. These are the few provisions of the acquisition of the citizenship in our country. Same thing, just change the word. Just mention only the nationality, nothing else. Simple. It is also static question. Simply. No need of going into any other parameters. No, just play smartly. Your answer is complete. Similarly, when we talk about the loss of citizenship, so we say loss of nationality by renunciation, termination, deprivation. The three parameters which we apply in citizenship, same thing we apply in nationality. The only difference is at national level, you are a citizen. But if as an Indian, I represent myself internationally, I am national of India. So this is just nationality. Okay. Further, Describe the various powers and functions of the General Assembly, UN General Assembly. So what are the various functions of the General Assembly? I think all of you are very well aware, because that you must have covered in international relations as well. So simply refer the UN Charter, whereby the General Assembly functions are being given specifically. They consider and approve the United Nations budget and establish the financial assessments of member states. They elect the non-permanent members of the Security Council and the members of the other UN councils and organs. They consider and make recommendations on the general principles of cooperation for maintaining international peace and security. They make recommendations for the peaceful settlement of any situation among the with respect to the disputes of any state. They consider reports of the Security Council and other UN organs as well. And the most crucial, Assembly may also take action in cases of threat of peace, breach of peace, or act of aggression when Security Council failed to act owing to the negative role of the veto power of the permanent member. In such cases, Assembly has the power to initiate action at its own end. So sometimes it works as a substitute of Security Council as well in such kind of scenario. Okay, so you simply mention what are the major functions of the UN General Assembly. Once again, very simple static question. Nothing else. Simply just mention the powers and functions of the UN General Assembly. That's all, nothing else. And this is a 20-marker question, and try to relate the function of UN General Assembly sometimes with the UN Security Council as well. That in case of veto power by the UN Security Council, General Assembly has the power to pass the resolutions as well. Okay, so the functions and powers, just simply visit the website of UNO, and you simply get the prepare one write-up only and just note it down. Simple, nothing else. Okay, play smartly, works very smartly. Explain the maxim pacta tertis nec nocent nec procent with the relevant case laws. So basically, in international law, I don't know how many of you are aware about this particular maxim, but this particular maxim you can understand with the help of the, you can say, law of contract. Like for example, in law of contract, we know very well that when two parties enter into an agreement, into a contract, only those parties are bound by the contract. But sometimes the stranger to the contract, the third party who is not a part of this contract, may also be bound. So this is the same principle, the pacta tertis nec nocent nec procent, in which if a treaty has been signed between country A and B, then how this treaty can make country C binding? This maxim simply says, normally it is the parties to the treaty who are binding by the obligations of the treaty. And this has been given also under Article 34 of the Vienna Convention on the Laws of the Treaties 1969, which clearly says only the parties to the treaties are bound by the treaty. But there are certain exceptions as well, whereby even the outsiders are also bound by another country who is not a signatory to this treaty, may also be bound by this treaty. So Article 35, 36, 37, 38, these are the 4 articles which are the exception to this maxim. So basically, like for example, Article 35 of this Vienna Convention on the Laws of the Treaties 1969 says, an obligation of the third state emerges from an arrangement if the third party gives its approval or assent that yes, I am also bound by this treaty, then this Article 35 makes that particular country also binding by this treaty to which it is not a signatory. So Article 35 simply says, if the third party so explicitly acknowledges the obligation, If the third party, third state expressly acknowledges the obligation, it makes it binding. Similarly, Article 36. Article 36 says, if the parties to the treaty, basically they enter into some arrangement with the third party or to some other states, basically, and they also give their consent. So in such a case, this maxim also provides that this another country, the third party, will also become a, you can say, binding with this treaty. So basically, under Article 35 and Article 36, basically, the point is, under Article 35, the third state is actually accepting the terms and conditions in writing to this agreement, explicitly, expressly. While under Article 36, basically, we have to decipher this with the intention of the third party, intention. So it might be indirectly, it might be, you can say, implied in the conduct of the parties. Similarly, Article 37, if a commitment at the end of the third party under Article 35 is there, and if the obligation is being modified or changed as per the requirements of the consenting parties to the treaties, under Article 36 as well, it will make it binding. Similarly, Article 38 we have, which also talks about, basically they are just, supplementary to each other. They are just the, the extension of 1 point 1 by 1, nothing else. So it has mentioned about the case basically. So you can mention in this case, the North Sea Continental Shelf case. North Sea Continental Shelf case. This case you can mention in support of your answer. This is one of the interesting landmark case about the Netherlands and Denmark at one side, okay, and Germany at other side. It was about, you can say, demarcation of or delimitation of the continental shelf actually. Okay, so that you can mention. So this is one of the case which is you can, you should also mention in support of your answer, nothing else, okay. Then comes right of self-defense under this international law and right to preemptive action. Once again, play smartly. The same kind of right of private defense you have in IPC, same kind of right of self-defense has been given in international law. So in international law, we have been given this right of self-defense. Basically, in international law, just on the very same parameters under Article 51 actually of UN Charter, which talks about that every country has a right of self-defense. If there is any danger, any risk or any aggression or intervention into the internal matters or sovereignty or integrity of any country, they can take action. You can quote an example over here of Bangladesh. At the time of Bangladesh war, a grave human crisis, the crime against humanity was taking place. And due to that, India has intervened into that matter. So Pakistan put an, this allegation against India that India has intervened in their internal matter. But India contested by saying that, no, it was our right of self-defense because of this Bangladesh, Bangladesh's, person crisis. India was witnessing a grave kind of wave of the migration in its country, and which is posing a serious security risk. And accordingly, we have interfered. And all of us very well know what happened ultimately later on. So Article 51, all of you should mention in support of your answer about this right of self-defense. Okay. And Article 51 simply says that nothing in this present charter shall impair the inherent right of individual or collective self-defense. Even the self-defense can be individual and collective. So it is just at par with the right of private defense. So whatever parameters you have, like, it should be reasonable. It should be within limits. It should not be in excess. So all these points only gives you an idea how exactly this right of private defense, just like right of self-defense in international law, both are same. Just the wording will change. Only the wording will change. Okay? Simply. When is an aircraft to be in flight for the purposes of the Convention of the Suppression of the Unlawful Seizure of Aircraft? Actually, it is Hague Convention. It is actually Hague Convention, in which the meaning of in-flight is given because it is about the hijacking, actually, the hijacking of the airplanes. So if you refer, I simply mention you the article of this particular convention and the Hague Convention of 1970. Under this Hague Convention, before this Hague Convention, there was a Tokyo Convention, and after this there was Montreal Convention as well. Actually, this hijacking was not considered as a crime earlier. It was considered as a crime later on, and finally, when it was considered, it evolved gradually. So this law about the hijacking has not, you can say, at the very same time it became a law, proper law, but through some gradual process, it become a proper law. So basically, step-by-step process of growth of this hijacking law. So in 1970, Article 3 of this Hague Convention says, for the purpose of this convention, so you have to refer just Article 3, number 1 of this convention, which says an aircraft is considered to be in flight at any time from the moment when all its external doors are closed following embarkation until the moment when any such door is opened. So when the doors are closed for embarkation and when they are, till the time they are open for disembarkation. So in case of the forced landing, the flight shall be deemed to continue until the competent authorities take over the responsibility for the aircraft and for persons and property on board. So it simply says what is the meaning of this in flight. Further, it says the convention is not applicable to the aircraft used in military, customs or police services. But for your sake of purpose, you have to just focus upon the in flight, only Article 3 Clause 1. This is more than sufficient for you to mention the meaning of this in flight. Okay, you have to little bit mention about the historical context in which this Hague Convention took place. First Tokyo Convention, then Hague Convention, which is about the recognition of the hijacking as an international crime. Okay, and then start mentioning about this Article 3 Clause 1, and for the this is all about nothing else. Just mention only in the limited words. Do not extend the word limits. And then it is saying, it is talking about mainly the delineate the obligations of the said convention imposes on the state parties. For this purpose, we have to refer few articles. I just tell you, first of all, you have to refer Article 4, Article 5, Article 6, Article 7, Article 8, Article 9 and Article 10 and 11 and 12. That is more than sufficient for you. So Article 4 till Article 12 you can refer. These articles actually talk about, like, first of all, extradition. Like if the offender is being caught, then what should be the process of extradition? It also talks about jurisdiction, like which state will have the jurisdiction over that criminal. So generally, this Hague Convention provides, number 1, the contracting state, means all these contracting state under this convention, they shall take measures to establish its jurisdiction over the offense of hijacking and any other act of violence against passengers or crew committed by the alleged offender. So it means the states are basically liable to keep, you can say, to put that offender behind the bars. Like for example, in case of few hijackings of Indian planes by Pakistan-sponsored terrorists, in many of the cases, Pakistan has not given punishment to those offenders, and even Pakistan has let them off, from this punishment. So this treaty or this convention basically provides that the offender should be prosecuted. even if by the state in which the plane actually lands, or in a state from which this plane belongs actually. So you can say if the airplane belongs to a country A and now it has been into country B, then both countries will have the jurisdiction over the offender. Normally the priority should be given to the country A to which this plane belongs, because we generally consider the floating island rule, or we can say the flag rule actually. Okay, so these provisions basically provides what are the various rights and duties of the contracting states of this Hague Convention, which are mainly concerned with the extradition and jurisdiction of the plane and the punishment to be given to the offender. So these provisions are mainly concerned with this discussion only. So you can refer Article 4 till Article 12 over here. Only a summarized version, nothing else. So no need of remembering all these articles. Simply mention the parameters given in these articles. Okay. What is the most favored means of decision making at World Trade Organization? And under what circumstances can decision be taken by majority votes? And which decision requires super majority votes? Is there any need to reform the decision making process? Discuss. So first of all, we have been given various kind of questions in this single question. So in this single question, one by one, we will try to figure out the answers to each and every question. Okay. So so in this particular question, we will try to figure out what should be the answers of each and every question now. Okay. Like for example, what actually happens in case of WTO? In World Trade Organization, actually, the decisions are taken. The decisions are being taken in WTO by the consensus. By the consensus. Ordinarily, decisions are taken by the consensus of all members. Of all members. Even if a single member is not agreed with the decision, so generally we try to come to the we try to pacify that country and we try to come to the consensus only. So generally the process of this decision making at WTO is consensus. But generally what happens in consensus, if no one formally objects, if no one formally objects, in such case we generally follow through the consensus. But what happens if there is if someone is giving any objection? So generally other members try to pacify that person, that country, and if that country is not agreed with this decision, in such a case we have to go with the voting. We have to go with the voting. And the voting are of two types, you can say. Generally, the voting actually happens by the simple majority. By the simple majority basically in few cases, and in few cases we do require super majority as well. We do require super majority as well. So how exactly this particular, you can say, majority through simple and the super majority are being decided, that I will discuss with you right now, and whether there is a requirement of the reforms or not, that we have to just understand now. Okay. So in case of WTO, first of all, just please note it down. The formal process of WTO first. The formal process of WTO. Actually, in case of WTO, we have been given, there is a proper kind of, you can say, kind of organization structure actually. Like for example, ministerial conference. Ministerial conference. Second, do we have the General Council. And in case of this General Council, further we have been given another subordinate councils as well. Another subordinate councils as well. Like the Goods Council, basically. Okay, you can say the GATT, basically. Then Services Council, GATS actually, then TRIPS Council. So we have been given these three small councils as well. So generally what happens in case of ministerial conference, how the decision making bodies actually take decision. The ministerial conference is the biggest or the highest decision making body. It includes all WTO members actually. And they meet at least at least once every 2 years. So every 2 years they try to meet at least once. Okay, every 2 years. And generally, the decisions are being taken in this WTO by the consensus of all members present over there. But if there is any, disagreement of any particular member, in such a case, we go with the simple voting. Simple voting. In this simple voting, with the simple majority, you can say, if it is more than 50%, actually it is if it is 51% or more than that, so in that case, generally the resolution or the resolution is being approved actually, in case of any conflict as such. Okay. And then further, the General Council. General Council basically looks after the day-to-day functioning of this WTO decision making, and they work in a different three capacities basically. Generally, what happens? All members, they appoint their representatives or ambassadors to this council, General Council, and this General Council works in three capacities: dispute settlement body, trade policy review body, and the General Council for all other matters basically. Okay, and the subordinate councils this General Council has for the decision making is GATT for the goods, GATS for the services, and TRIPS for the IPRs. So by this way, you can say these are the few points by which decisions are being taken in case of WTO when there is no consensus. But the point is, what is supermajority and how the supermajority is also, you can say, relevant for all of us. So what happens in case of, this in specific cases, like for example, if the WTO has to take a decision with respect to, you can say, I just write down over here, you please note it down because it is generally not given in the books actually. Only in very limited cases, supermajority is being used, in very limited cases. And one of the limited cases, in case of interpretations of provisions of WTO, the WTO provisions, or in case of amendment of provisions, and in case of, you can say, waivers, if any waiver is required from the WTO provisions. In all these three cases, we do require supermajority. And supermajority is basically 2/3 or 3/4. Depends upon the situation. So there is no as a specific criteria, so that depends upon the situation. The biggest issue about the reform is basically because, you simply mention what is the most favored means of decision making, basically consensus. Under what circumstances decisions are taken by majority? I have just explained you in case of in case of any disagreement, and in case of supermajority, I have just given you this idea and the need to reform. The need to reform is basically the biggest issue with the WTO working is generally there are few groups of countries, generally developed countries. Generally developed countries, they have their groups actually. So whatever decision they take, whatever things they decide, they generally go by that. And they try to influence their decisions upon the developing countries as well through carrot and stick approach actually. And developing countries, because they have, not as such any say in such kind of decisions, and they're mainly dependent upon developed countries for their other requirements. So generally they are, you can say, taking they are coming in agreement with them because of this kind of pressure as well. So the ultimate point is, what can be the better decision, better solution? The better solution is basically on the basis of the regional groups. Regional groups can be created. We do have 5 regional groups in case of other kind of international organizations actually. So these regional groups can serve the purpose. So these regional groups can have, you can say, their representations in the decision making body of WTO, and ultimately this decision of that, finally this regional bodies, regional groups actually, when they come together, then sit together by the proper representation, then decision making will be a better way of deciding the things in case of WTO. Otherwise, developed countries by hook or by crook, they try to influence the decisions of developing countries or the least developed countries only. Okay, so this is the way you can write down this answer, nothing else. Okay. Last question, core principles of international humanitarian law. Core principles of international humanitarian law. You know, this international humanitarian law is, the important topic as of now because of the Russia and Ukraine conflict as of now, which is going on. And that is the reason it has become one of the main topic of discussion right now. And this international humanitarian law is applicable during the times of war or conflict. So whenever there is a situation of war, we have to discuss about the international humanitarian law. So what are the various principles of international law? That is the question actually. But before that, you should be very well aware what is the fundamental basis or what is the difference between the international humanitarian law and human rights. So generally, international human rights are applicable at the time of the peace, while the international humanitarian law is applicable at the time of the war. And the kind of principles of international humanitarian law, there are basically 5 main core principles of international humanitarian law which you should explain. The distinction between the civilians and the combatants. This principle simply provides that you cannot kill any civilian during the time of war. Only the combatant shall be killed, and when the combatant is not having the weapon with him, when he is unarmed, he should not be killed. Okay. Then another principle of IHL is the prohibition to attack those horse they combat. Means the persons who are not engaged in hostilities. So it is also about, you can say, when the combatant is not having any weapon or he is basically unarmed. In such a case, that person, when he is not involved into such hostilities, so that person should not be killed or should not be attacked upon. Another point is the prohibition to inflict unnecessary suffering. So no inhuman treatment should be given to the civilians or the combatants. They should be treated with the dignity only. That is another principle. The principle of necessity. The principle of necessity says that the attack, the intensity of the war should be up to the proportionality, up to the necessity. So whatever kind of, the support you, whatever kind of, attack you are witnessing, only that kind of attack you should do. Otherwise, your attack should not be more than the attack of the another party. It should be proportional, just like right of private defense. And the last is the principle of proportionality. It simply provides that it is just like a continuation of this thing only. So the response from your side should be proportional to the attack of the other person. So no country should go into the mindless killing of the civilians or the combatants. No one should go for the use of the nuclear weapons. No one should go with the use of the biological weapons or the weapons of mass destruction. So these are the things which are prohibited in this international humanitarian law, which are mainly the laws of the war, how the war should be conducted. So by this way, you can mention this international humanitarian law as well. So this basically concludes this discussion now about paper 1. In the next session, we will discuss about paper 2 as well. And for the time being, thank you all of you. Thank you very much for patiently listening to me. And if you have any queries or any issues, please let us know in the chat box. Thank you all of you. Thank you very much. Thank you.